Can an accused demand narco analysis test to be conducted as a matter of right? Hello and welcome back to Live Law Academy. And today we will be discussing this issue. But first things first, what is this narco analysis test? It is a test. In this test, the procedure is that the accused or any person, it can be accused or witness, the person is injected with some drug, and usually it is sodium pentothal. Then what this drug does to that person, it affects his or her mental capacity, mental functioning, in the sense that person becomes more talkative and less guarded. The person tends to share more details. His or her reasoning power is lessened, right? It is on the lower side because of this drug. But just because a person talks more does not mean that he or she is stating the truth. And that is why the courts have been very cautious while approaching with these tests. The landmark decision on this point is a three-judge bench decision in the year 2010, which was Selvi versus State of Karnataka. You must have heard this case quite a lot because it is one of the landmark decisions of the Supreme Court. In this case, the main issue before the Supreme Court was whether tests like narco analysis, polygraph, and brain mapping can they be conducted without the consent of the person, mainly the accused. The court held that no, it was an absolute no. Why? Because we have Articles 20, Subarticle 3, and Article 21 in our Constitution. Article 20, Subarticle 3 gives us the right, a fundamental right, right against self-incrimination, which simply means that we cannot be witness against ourselves. We can be, but nobody can compel us. Then we have Article 21, which is right to life and personal liberty. And right to life and personal liberty includes mental and bodily integrity. It has been interpreted to even include privacy very clearly. So the court said, in light of these articles, in light of these fundamental rights, nobody can be compelled to undergo such tests. So involuntary tests are out of the question. Then the Supreme Court held that voluntary tests can be conducted, and even then there have to be some safeguards. The court pointed out some NHRC guidelines in that regard, and we'll be discussing the new case on this point, and the same guidelines were referred to in this case, in that case also. Then the Supreme Court has also clearly laid down in Sevi versus State of Karnataka that the statements as it is will not become a piece of evidence. They can be admissible only when statements lead to some discovery. Then only they will be admissible under Section 27 of the Indian Evidence Act, and now I think it is proviso to Section 23 of Bharatiya Sakshi Adhiniyam, discovery statements. Right? So this is the law regarding these tests, voluntary and involuntary nature, as highlighted by the Supreme Court in Sevi versus State of Karnataka. Now let me take you through a recent case, and that is Amlesh versus State of Bihar. You can note down the citation. 2025 Live Law Supreme Court 674. 2025 Live Law Supreme Court 674. This is the citation. Now, what happened in this case? The wife was missing under mysterious circumstances, and the husband accused informed the relatives of the wife about the same. But the relatives were of the opinion that this information is not a true information, because the husband and the in-laws, they used to demand dowry and also used to beat her, the wife. So naturally, something was fishy according to them, and they gave this information to the police. The police registered an FIR, and investigation was being carried out. During the investigation, one of the co-accused confessed to the killing, and also that the body was thrown into the river. This was the confession. Now, interestingly, when bail application was being heard before the High Court recorded something unusual. There was an insistence from the police that they will be conducting narco analysis test on the accused as well as certain witnesses. And the court recorded this and then uh, delayed the bail hearing, right? The appeal was now before the Supreme Court because of this. And the Supreme Court framed three questions. One, whether such a record uh, whether such a request can be entertained and recorded by the High Court, especially in bail matters. Second question was, even if in cases where there is voluntary participation in such tests, can they form sole basis for the conviction? And lastly, can the accused demand such tests to be conducted as a matter of right? For first question, the court said no, relying upon the Selvi versus State of Karnataka, that there cannot be involuntary participation in such tests. So no one can be compelled. So no such kind of request be entertained. Law does not permit it, and the same cannot be carried out under the directions of the courts. As to the second question, the court said, again relying on Selvi versus State of Karnataka, that statements made during such tests cannot form basis for the sole cannot form the sole basis for conviction. Now comes the last question, that is, can the accused claim such tests to be conducted voluntarily and as a matter of right? The Supreme Court clarified that yes, accused can make such an application at the appropriate stage. But what is that appropriate stage? That appropriate stage is when the accused is called upon to give evidences during the trial. To when the basically when the accused is called for his defense during the trial, that is the appropriate stage to make such an application. And this right is not an absolute right; it is not an indefensible right. Even when such an application is made, the court is required to have all the circumstances of the case in mind. For example, the consent and the surrounding circumstances, and whether there are any safeguards that are available, or there can be some directions around those safeguards, right? Only then the application will be allowed. So, if I have to answer the question that we put at the very beginning of this session in one single line, then it would be that yes, the test can be demanded as a matter of procedure, but it is not an absolute right. The judgment clearly states. So, this was all on this particular issue. And if you have not subscribed to this channel, then I request you to subscribe it so that you do not miss any such informative sessions. And if you found this video to be informative or to be of some use to you, then Please comment consent with a thumbs up in the comment section. Thank you very much and take care. Have a good day ahead.